Chaudhuri. And at present, we have 10 new positions for data scientists and engineers. And I'll share this link later. But now, for anyone who may be finishing up a graduate program and looking for their next position, we'd certainly appreciate you considering Thomson Reuters Labs and their new site in Bangalore. Okay, so as a past president of the IAAIL, or the International Association for Artificial Intelligence and Law, a part of my ongoing responsibility is to keep in mind the health and well-being of the AI and law community and its growth. So the AI and law community could probably do a better job in welcoming new students, especially graduate students and other related researchers, to come under its tent. So what I'm going to talk about in the next few minutes is a gentle introduction to the community and a bit about its history. So this is the journal that the community established starting in 1992. Some of you may be familiar with the names of these editors here. Kevin Ashley, I believe he's one of the other speakers this week at the Sales Symposium. Trevor Ben-Shkapen has been around for a long time. And Giovanni Sartor. But the journal also has an extensive editorial board with specialists covering a broad range of topical research areas who review the submissions. And it's published by Springer. So if you were new to the field of AI and law and its community, and you were looking for one issue that would help bring you up the learning curve about past AI and law research, within the last 10 years, there was this special issue, and it reviewed 25 years of the international conference, the ICAIL AI and law conference. And what it did was it selected 3 or 4 of the seminal research papers per year. So the conference takes place every 2 years. So this was about 13 conferences covered. And so there's obviously a digital version of this available, but this would be an excellent way in which to go back and take a look at some of the critical research work that's been done over that period of time within the community. This is the conference and its proceedings that 25th anniversary journal issue was addressing. This specific proceedings that's shown here comes from the ICAIL, the one before last, which was from London in 2017. But as I mentioned, the conference takes place every 2 years. The proceedings historically have been both in print and digital versions. It's accessible from the ACM Digital Library. So if you have an ACM membership and access to the digital library, you have access to all of these papers. Typically, there's full length or 10-page, short, 5-page, and demo papers in the proceedings. An introduction from the PC chairs. Atypically, there's a listing of the workshops, and it's hosted by that IAAIL, or the International Association for AI and Law. And I'm going to speak more about that a bit later. So how many ICAIL conferences have there been since the beginning? This summer's will be the 18th. So the next conference is coming up in about 3 weeks. So now you know what I mean when I say, in response to the hype, AI and law is not a new development. So in general, the conference rotates between Europe 1 year and North America the next time, though there have been exceptions, with ICAIL in 1997 taking place in Australia, in Melbourne. This year was also to have been such an exception, which was to have been held in Brazil, but because of the pandemic, it will be an online conference. So if you're coming from India, you may ask the question, does the IAAIL support regional conferences? And actually it does. There is a European version called EURIX that takes place every year, usually at the end of the year in November or December. This originated in the Netherlands, but since then it's been hosted by cities around Europe. And there's also in Asia a conference that takes place every year called EURICIN. And it typically takes place either in Q2 or Q4. If it's an ICAIL year, it typically is hosted in Japan. And you can see the title here, it's workshop from 2020. Closely associated with Eurocent is a competition known as COLI. Some of you may be familiar with that. It stands for the Competition on Legal Information Extraction and Entailment. It's held every year. If it's an ICAIL year, it's held with ICAIL. This year's will be held again in 3 weeks. And if it's not an ICAIL year, it will be held with Eurocent, so towards the end of the year in Japan. And generally, this competition consists of 5 tasks involving either case retrieval or statute retrieval, and entailment, legal question answering, and other associated tasks. And the tasks can involve either using a Japanese text or an English translation, let's say of Japanese case law or statutes. So, as with many research and development communities, one can often find some of the latest and hottest work showcased less at the main conference and more at its associated workshops. So this is a list of the workshops from the last ICAIL, which took place in Montreal the summer before last. And you can see there's quite a diverse set of topics focusing on various technological capabilities, some reasoning and things like that, as well as a multilingual workshop, which permitted research works to be submitted in different languages. And it's also worth mentioning that typically there's a number of tutorials as well, and the last ICAIL was no exception. Okay, so what organization hosts the ICAIL conference? You've heard me mention this International Association for Artificial Intelligence and Law, and this site that it hosts contains a rich mix of current and historical information about the community and its activities, including the current executive committee, past committees, past conferences, etc. So it's no secret that the largest contributors to this community have been from academia, often in conjunction with government support of various forms. So I put together this slide, which shows the sort of the demographics of the community, which is a partnership between universities and industry and government. And you can see, I mean, this is by no stretch of the imagination complete. There are numerous other universities and government agencies unmentioned here, but these are some of the principal ones who've through their research labs or their graduate students have submitted research and published research within the community, either at ICAIL or in the journal. And by the way, I might say, if anyone has any questions, especially if they're clarifying questions or relatively short, I will welcome them. You can either ask them at the end or at an appropriate point during the talk. So when I gave a practice presentation for this at Thomson Reuters a while back, one of my colleagues asked for a slide through this lens. So I updated an earlier version of this from Tom Gordon, a past president of the International Association. And from this perspective, we can see that the largest source of participants in this community is from computer science and AI, followed by law. There are also a number of researchers with a background in philosophy or logic, but usually in combination with one of the other fields, as you see here. And obviously, there's numerous other researchers, especially in the last decade, that are not shown in the figure. But these are some of the luminaries who've been regular participants and contributors to some of the research activities of the community. So before we move on to the next part of my talk, I'm going to spend a minute focusing on one prominent luminary associated with the field. I wonder how many of you have heard of Richard Susskind. So aside from some of the individuals who are mentioned in relation to the journal or those who've been leading the program committees for the international conference, if there were one individual that you should know about in the area of AI and law, it would probably be Richard Susskind. So he's not only a practitioner, a lawyer or a solicitor, but he also frequently takes a step back and looks at the broad view for the problems facing practitioners. And you can see that he has this kind of epic sweep of publications books going back to the late 90s, The Future of Law, Transforming the Law, The End of Lawyers. Most recently, he's published a book entitled Online Courts and the Future of Justice. So we call him a legal services visionary. Today, besides being an author, he's a lecturer. He's an advisor to the Lord Chief Justice in the UK, and an AI and law consultant. And it turned out that, well, his participation in this community is extensive, and it goes back to the very beginning. So at the very first ICAIL in Boston, he submitted a paper that was entitled Expert Systems in Law, Out of the Research Laboratory and into the Marketplace. And he had a paper in the following ICAIL as well about the latent damage system. Subsequent to that, he was the conference chair when it was in Oxford in '91. And since then, he's given a couple of invited talks at the conference in Edinburgh in '03. He talked about the role of AI in transforming the field of law, and he actually wrote a book on that. And the conference before last in London, he gave an invited talk entitled A Manifesto for AI and Law. And in that, he spoke about the 4 stages of acceptance of AI and law in the field. And it was rather amusing. He said that back in 1986, people's general reaction, professionals, to this notion of AI and law is that it was worthless nonsense. Then 10 years later, in 1996, he characterized that as the reaction as saying, this is a very perverse point of view. And then still 10 years later, he said the professionals' response had evolved, and they would be saying something like, this is true, but quite unimportant. And then later in the decade, this past decade, the response finally was, oh, I have always said so. So these are the so-called 4 stages of acceptance of AI in law. Okay, so one other note. So I first started becoming active in the AI and law community around the year 2000. And I don't go back as far as people like Thorne McCarthy, for example, who attended that very first ICAIL in 1987. But as I performed research for this talk, I discovered some details about the community that quite frankly surprised me about that first dozen years or so before my involvement. And I'll share some of that with you momentarily. So in 2007, the then IAAIL president, Tom Gordon, stated that argumentation was the central pillar of AI and law, argumentation. And he actually expanded a keynote talk around that theme. So I was surprised when I observed, some of the things that I'm going to share with you in the next few slides. But if we imagine ourselves as an attorney or a lawyer, a solicitor, some form of legal practitioner in the early days, looking for the ability to identify language patterns and legal strategies to use in legal cases that would produce more successful legal outcomes, we would have discovered that capability doesn't exist at that point, but we are getting closer. So let's see what some of the technological developments have been in the community over these years. So if you bear with me, one of the things I did was I went back for each decade of the conference and the proceedings, and I took the abstracts from the submitted papers and I put them into a word cloud application. And some of the things that come up here are worth noting are in the early days, not surprisingly, expert systems, text retrieval systems, in particular, conceptual information retrieval, case-based reasoning, and knowledge representation, which would come under text retrieval systems. But to distill that down, some of the dominant research themes in those early years, in the late 80s, for those first international conferences, were information retrieval with an emphasis on conceptual IR, expert systems, case-based reasoning, again, closely tied to information retrieval, and logic programming as a means of implementing a research system. So what about from in the 90s, from 91 to 99? So worth noting here that we have, knowledge-based systems, in particular legal knowledge-based systems. We have, again, conceptual information retrieval. It's still around, combined with legal databases. We also have, knowledge representation still around, computational models, and legal argumentation and argument, and of course, reasoning, which we see that front and center. In the 90s, again, just to distill that down, so the dominant research themes: legal knowledge-based systems, case-based reasoning, expert systems, conceptual IR, logic programming is still around, and we begin actually to see some implementations of neural networks, even back then. Some lesser research themes that one starts to see is legal tutoring systems, with an eye towards benefits for law students, legal support systems, such as online dispute resolution, question answering, a very early system coming from some of the researchers in the field, and opinion classification. Moving ahead to the early 2000s, and again, another series of 10 ICAILs worth noting. So legal information retrieval, this persists. What is new? Some topics like text mining, especially argumentation mining. And we also begin to see fields like e-discovery. So electronic approaches to uncovering information in preparation for litigation. Excuse me. And again, to sum that up, the dominant themes: information retrieval, legal search, including XML-based retrieval systems, e-discovery, which is also a branch of information retrieval, ontologies, automatic summarization, and some of the lesser research themes: legal tutoring systems, again, looking to the needs of law students, online alternative dispute resolution, machine learning and analytics is continuing to make its presence known, argument mining, and topics like computational law and transactional law. Okay, so I'm going to continue here, and since 2010, looking at the conferences for the first part of that decade, worth noting: machine learning, front and center, including Bayesian reasoning, recurrent neural networks, contract language. There's an increased focus on the needs of transactional lawyers who are heavily dependent on contract language and its clauses, and evaluation. This is really arguably central to everything that we do in AI and law. How can we know if a system is beneficial, if it's performant, if it delivers value to legal practitioners, if we cannot introduce valuable metrics and evaluate the underlying deliveries? So again, for the 2010s and follow, dominant research themes: IR, legal search, e-discovery, and what's been called sense-making, information extraction, legal knowledge acquisition, question answering systems persist. We talked about evaluation, and those lesser themes: expert assistance, online or alternative dispute resolution, decision support systems, and Bayesian networks for reasoning. So I've been suggesting that the International Association has a monopoly on AI and law over the years, and clearly that's not the case. So I want to make that clear right now. Anything but the question does ask, what's been the impact of the community on the field, the AI and law community and the IAAIL community? Well, and via some of its activities, like the conferences it sponsors, the associated workshops, the proceedings that are an outgrowth of that, and the journal. And to be candid with you, the answer would be mixed. The impact on the community would be mixed. So ICAIL and its workshops have demonstrated some commercial successes with some of the works and some of the applications that have been showcased there. There have been startups that have participated, and other luminaries, people like Richard Susskind. Examples of commercial successes: WIN, which was Westlaw's first version of a natural language engine, was first showcased or demoed and had publications about it at ICAIL. Lex Machina, which is a Stanford startup that's now a part of LexisNexis. Its its creators also published at ICAIL and presented some of their early work. And similarly, seminal e-discovery works have been shared in a series of 7 dossier discovery and electronically stored information workshops. But that said, there still is a tremendous amount of activity in the AI and law domain that render themselves, that come into existence in pockets outside of IAAIL. I mean, for example, Stanford has its Center for Legal Informatics. This is an example. There's a tremendous amount of fantastic research work and even startups that have originated there, and beyond that, even in the startup space. So this sort of leads to a subsequent topic that I'm going to spend a few minutes talking about, and that is the role of legal startups in the field of AI and law. And this is, clearly outside the tent of the International Association. So, so here is a plot of legal startups cumulatively and by year. And I wanted to take some data that predated the pandemic. So this was accumulated in 2019, the year before the pandemic, just so that we could see the trends in a pre-pandemic world. But one question I would ask is, do we think there'd be this many legal startups if the AI and law community was, satisfactorily meeting the needs of the legal field today, or in the past decade? And as we can see from this plot, there's been an impressive and growing buildup of legal tech startups especially since 2010, and even when this was collected in 2018, it seems like it started to flatten out there, but the data collection may not have been complete in 2018. So, but this is, we're talking about literally and collectively thousands of legal startups. So this gives us a very clear indication that, the research community itself, the public research community, as illustrated by IAAIL or ICAIL, has not had a monopoly, and in fact has not been completely meeting the needs of legal practitioners, which is why a lot of these startups and these innovative ideas have come to fruition. So here's another plot by continent, and here I divide up the space into law and legal tech, and let me differentiate between the two. So we see this distribution of legal tech startups versus law or tech startups by region of the world. So, North America and Europe obviously continue to be where the action is, but by legal tech, this is referring to technology solutions for the legal profession that doesn't require them to change their business model. So law firms can continue to, make money, and corporations and corporate legal departments can continue to save money. By law tech, or by law here, I should say, in tech in parentheses, this is more like a do-it-yourself legal services for businesses and consumers. So allowing them to do more on their own. So it's a law product or a law service that enables them, imbues them with knowledge or processes that lawyers would normally do. But it can actually be done through a machine. So very eye-opening, and especially obviously this is a hot topic in North America. I'm not sure, in our discussion after, in our questions and answers, one of the questions that I'm going to pose to the audience is to enlighten me on, the role of legal startups, let's say in a place like India. Obviously it's dwarfed, the curves here are dwarfed by what we see in Europe and North America, but still there's a non-trivial curve there for legal tech. Those technology solutions. So here we have the legal tech landscape, a map that colleagues of mine put together at Thomson Reuters, and just to help add some clarity here. So starting on the bottom right, we have some startups that are involved in that field of online dispute resolution. So so trying to bypass the courts, if you will. Above that, we have case management tools for law firms and others. Above that, we have e-discovery. And again, this is a bit dated, and it's certainly by no stretch of the imagination complete. To the left of that, we have tools for legal education. Again, some of these startups have come from law professors who've been constantly challenged by trying to communicate the complex ideas of law to their law students. Below that, we have legal research tools. To left, litigation funding. To the left of that, business development in the marketplace. There's practice management tools, document automation, and finally, on the bottom there in the middle, contract management analysis. And again, this is a very hot field. There's been some mergers in this field, and this by no stretch of the imagination is complete, but some of those names here that you may be familiar with. Okay, so what role do legal startups play in this landscape? What can we say about all this activity that we've seen in the charts in the AI and law space, and the diverse problems that are being addressed? Well, I think it's safe to say that these legal startups tend to fill gaps in ongoing research where needs for legal practitioners are not being met by what's been coming out of the research community. These activities and of the various startups tend to be quite focused. So they may address a specific need of a legal practitioner or a specific problem or pain point. For example, the distribution of motions in the treatment of a course of litigation. This is something that's been addressed in the US side. So these startups will often begin with just a single jurisdiction, maybe a state, like a US state, like California, or a specific legal practice area, like intellectual property. And then they'll base their next steps on past performance, and often tied to the likelihood of obtaining additional funding. But there's trade-offs there between expanding your coverage, let's say beyond one jurisdiction like California, and accuracy. So obviously, in an ideal world, you'd be able to both expand into other jurisdictions and continue to improve the accuracy and the value of your results. Okay, so that ends my discussion of the role of legal startups in AI and law. And I'd like to now move from a discussion of the past to the presence in the field. So I'll start with, here is just in the last few years, one issue, a special issue of the AI and Law Journal, in which I basically co-guest edited with Carl Branting, who is another past president of the IAAIL Association. But this issue focused on legal text analytics, and in particular, it emphasized the shift away from small, narrow, often theoretical models in the legal domain to data-driven, empirical, often statistical models for addressing the challenges within the legal practice areas. But what kind of progression can we talk about? What kind of messages can we take away from work that was illustrated in that special issue and beyond? Let's take a look. In the early days of the field of AI and law, there were some very big expectations, and whether or not the field was able to live up to those expectations is another question. But initially, the foundations of the field going back to the 70s or the 80s, there were very grand visions for AI and law, like those visions for artificial intelligence as a whole. And there was a lot of focus on legal knowledge representation, formal computational models for reasoning based largely on inference and argumentation. There was also an emphasis on legal interpretation and decision making. And some of those early models were developed with domain experts, and they could even be said to be, expert systems, so narrow focused expert systems. Taxman, that was developed by Thorne McCarthy that I alluded to earlier, maybe at least partially rule-based, could be said to be a system like that. It focused on a branch of the US legal code that treated corporate restructuring. And so these applications are often in subdomains, like the case of trade infringement, which were some of the systems that I believe Kevin Ashley and others had focused on back in the day. So what about today? How does today differ? And going into the future, as I'd mentioned, so today where everything tends to be more data driven. So we have the opportunity to harness large and growing data repositories. The whole approach to legal analytics and legal analysis has changed. It's now more about empirical and corporate-based approaches. The underlying models tend to be statistical. We can also invoke semantic, citation-based, or temporal patterns as well. And these techniques really enable new algorithmic approaches to the kind of problems that are being solved. So, but that said, the analysis continues to leverage core natural language processing, data mining, and machine learning, bedrocks and approaches. But nevertheless, deep learning and neural networks is making increased and significant progress in the field, and we're going to talk about some applications of that a bit later in the talk. Okay, so at this point, rather than continue to discuss the current or future use cases from 10,000 meters in the sky, as we've done, largely up until now, I'd like to focus on some new and exciting application spaces that involve neural approaches to deep learning. So some of you may be familiar with some of these transformer-based approaches, but if we were to talk about recent trends impacting AI and law, and really, just in the last handful of years, so going back to AI and law conferences, for example, in Montreal in 2019, in London in 2017, where neural approaches or deep learning approaches have started to make a real inroads into the community in terms of submissions, in terms of demos, in terms of the workshops. It can't be overstated. And I would say that the AI law community may have been slow to embrace some of these approaches relative to other communities, other research communities, and maybe other more general research communities. But even this year, I think this year, there was at least 20 or 25% of the papers submitted to the conference that were harnessing deep learning approaches in some form or another. And most recently, of course, the kind of transformers that we're going to talk about now. So what is this growing presence? Many of you may have heard of BERT, this bidirectional encoder representation from transformers. This was first reported on by Devlin and others in 2019. And this encapsulated a new language representation model. It was designed to pre-train this deep bidirectional representations from unlabeled text by jointly conditioning both the left and the right layers. And then subsequent to that, it can be fine-tuned with a single added output layer. So what BERT did was it created a state-of-the-art model for a range of tasks, including question answering, machine translation, text classification, text summarization, and others. So very impressive in what it was able to do. So Roberta, which was based on research work also published in 2019 by Liu and others. This is termed a robustly optimized BERT pre-training approach. So what Liu and his colleagues did was they tried to replicate the BERT study reported on by Devlin, and they found that BERT was significantly undertrained. And so they tried to carefully measure the impact of the key hyperparameters, as well as the training data size that was used in those early experiments. And what Liu showed was that how the hyperparameter choices have a major impact on the final results. And so with their emphasis on more keenly optimizing BERT, and in particular in its pre-training, they came up with state-of-the-art results against standard collections like the GLUE, which is this global language understanding collection, the Stanford Q&A data set, and the RACE set, which actually comes from China, and it's based on a test that they give their middle school students in English every year. So when you try to deploy these type of deep learning models in a production environment where speed and latency are major factors in its successful deployment, the size of these models and the speed of these models can be very challenging. So in 2020, San and others addressed that directly by coming up with a system that they called DistillBERT, a distilled version of bidirectional encoder. And what they did was they basically acknowledged that operating these large pre-trained models for NLP tasks can be challenging due to the size of the model, so it's hard to deploy, and due to the speed in which they can address some of these challenges in real time. So what they did was they proposed training a smaller general purpose language representation model, and then fine-tuning it for the specific task, for example, in the legal domain. And in their published results, they found that they were able to obtain a 40% reduction in the BERT model size, while retaining 97% of the language understanding capability, while still being 60% faster. So a very significant development and an outcome, especially for operations, enterprises, companies that are interested in putting some of these systems into real-time applications. So I'm going to also spend a few minutes talking about a couple of research works that address the legal domain in particular in the context of BERT type capabilities. And one is Legal BERT, which was published in 2020 by a number of Greek researchers led by Chalkidis. And another paper, which came out of Stanford this year, which focuses on how to obtain an optimal training for legal applications of deep learning systems. And this actually is a pre-publication. It's going to be presented at ICAIL, International Conference, in 3 weeks' time. Again, originally slated for Brazil, but it will be an online conference. So what about these two papers? Legal BERT by Chalkidis and others, they examined different deployments of BERT for downstream legal tasks while evaluating the model against different data sets. And what they observed was that the general guidelines for pre-training and fine-tuning of BERT are not always suitable for applications of the kind they're looking at, legal applications. And so they proposed, and this is represented in the figure down below, they proposed a systematic study of BERT applications using 3 variations. So first, the original or the out-of-the-box BERT. Second, BERT, which is adapted by adding additional pre-training on the domain-specific corpora. And you see that in the middle there. And then lastly, starting to pre-train BERT from scratch on domain-specific corpora, that is to say, legal corpora. So and then they also proposed a broader hyperparameter search space when fine-tuning for these downstream tasks. So along with their publication, they actually released a set of legal BERT models to assist legal natural language processing research and some of these other applications. So different versions of the 3 approaches that you see here. And these are freely available on Git. So moving to that second paper, coming from Stanford, which investigates, optimizing the role of training in some of these deep learning systems. They actually relied upon 3 core legal test collections, which are summarized at the top there, and most notably the case-hold collection, which they actually mention in their title, which they put together themselves, and it consists of over 53,000 of these basically cases. So we're gonna talk about that in a second. So the authors Zhang and others observed that it's unclear when researchers should rely on domain-specific resource-intensive pre-training and when not. The results seem to be mixed. So what they acknowledge is that legal applications have shown few examples where significant gains have been made when domain-specific pre-training was used. So they hypothesize, and the research paper is formed around this, is that the current results come from legal tasks that are too easy, and they really fail to meet the conditions that when legal pre-training can help. So as I mentioned, they present this new data set, the so-called case-hold collection, with 53,000 plus multiple choice questions that ask an individual to identify the relevant holding in a case, and they give a number of examples, only one of which is correct. So this is, they claim, to be representative of a difficult challenge. So they subsequently measure the performance of NLP task gains on the case hold collection and other smaller data sets. And they show that legal domain pre-training with custom vocabulary that they also talk about in the collection, in the paper, outperforms BERT pre-training on a general corpus. And lastly, they show that domain pre-training may be warranted when the task is similar to the pre-training corpus. So again, it's moving the needle. It adds a lot of clarities to some previously unanswered questions. And we're looking forward to the author's presentation of this at ICAIL in a few weeks. So I'm mindful of time. I know I was asked to take about 45, 50 minutes, so I'm gonna start to wind down here. I will mention one other thing. A colleague of mine and I, we also have a paper that will be presented at ICAIL in 3 weeks. I'm not going to talk about this now, but I will just whet your appetite by saying that what is significant about our paper of using transformers to improve answer retrieval for legal questions is that we have operationalized, we have created a production system for question answering. And we face some of the challenges that we just talked about for those large deep learning models. And so because we were not, basically, we had some constraints on what we could talk about concerning our own data, what we did for this paper was we took a publicly available data set, which is known as the privacy QA data set, and we actually treated that and put that through our production pipeline, and we compared it with a baseline model, such as an SVM, and we report on our findings of what it took to operationalize the system and to process the privacy QA data and the results we get. So stay tuned, and Andrew is actually going to be presenting that paper at the conference. Okay, so I'm going to just spend a few minutes concluding here while we look a bit further into the future, but acknowledging where we've come from. So just quickly, I'm going to revisit some of the trends that we have talked about, the past, the present, and where we're going. So initially, recall that we saw a focus on real-world systems that relied on expert systems, legal knowledge-based systems, conceptual information retrieval systems. And so in the early days, they really tried to develop operational systems and real delivery systems with limited success. And then subsequent to that, what I'm calling here the second generation, there was in the community a focus on argument, logic, rhetoric, legal philosophy. Models tended to be theoretical and narrow or limited computational systems. But the current trends, again, just to reiterate, are increasingly data-driven. The approaches to legal analysis are much more empirical, corporate-based, focusing on measurable metrics and evaluation, formal evaluation protocols. The underlying models, to be sure, are statistical in nature, but they can also rely on semantic, citation-based, or temporal patterns in the data. And as said before, these approaches can foster new algorithmic approaches to legal problem solving. So, yeah, and you'll notice on the bottom here, I have the curve here as cyclic because this is something that has become, I guess, a valuable set of operating principles within the community. Okay, so I'm not going to say much about this. In a version of this talk, I took a minute to underscore the importance of explainable AI. And this is kind of a subfield of itself under the umbrella of AI and ethics, where explainability and transparency and interpretability and equal access to justice are key themes. And that's what this slide is essentially about. So people, especially legal practitioners today, when systems are more and more dependent on AI capabilities, especially in the field of AI and law, legal practitioners become a little bit discomforted when they're presented with a black box. And so it's increasingly important to try to be able to at least provide some form of explainability of what's happening under the hood, either directly or indirectly. So some final thoughts on AI and law in the years ahead. And 2025 and beyond. So the field started with an impressive emphasis on real world systems, but over time, and as the realities and the challenges of developing those systems set in, there was a shift towards logic, argumentation, and related fields, limited research, theoretical works. Although actually, there was a small bit of research on almost a hybrid of the two. The argument mining is an example of that. So, but what we're witnessing is a surge of work focusing on solutions for real world problems today because of our computational capabilities at scale, given the power of our computing environments today with big legal data. Our applications of machine learning to legal problems, including deep learning applications, are persistent, are robust, are ongoing, are increasing. And finally, decision support tools we can envision will have, in the not distant future, predictive capabilities. Whether or not they become commercialized is an open question due to caveats. And when I refer to caveats, I'm talking about enterprises have to be careful if they are giving decision support tools that could make them liable for their suggestions. So it will probably be couched in some type of confidence scores or something like that, where it will be made clear that ultimately the decisions will be left with the legal practitioners and not with the systems themselves. But in the future, it's possible to envision, again, that sort of hybrid where we have a combination of strong computationally based, data-based, application-oriented, along with some of the kind of the theoretical argument models that we've seen in the past. So with that, I think I'm going to conclude and leave it open for questions and leave it to the organizers to help us navigate into the next steps. I think there's going to be a breakout discussion session to follow.
Right. So thank you very much. Fantastic talk. 30 years of AI and law. In fact, I was also not aware that this is that old, where people started talking about expert systems, etc. Right there. Anyway, so we have one question. So the one question is by Rajeshwari Sridhar. So could you specify some legal data sets, country-specific legal data sets that are published as an outcome of this ICAIL conferences? And then the follow-up question is, what is the most popular and stabilized legal domain, subdomain that has been studied and automated by applying AI-enabled techniques? So there are basically two questions.
So that's a good question. So one of the things that I can do there, this year, there was a fellow from Germany who established a GitHub site, which basically consolidates all of the different types of AI and law resources that were currently available. And these are not only just data sets, but there's code that has been made available by various labs or publications, and other types of resources, maybe algorithms, things like that. So it's a rich mix. And I know the number of data sets are limited. Recall that I mentioned that for our work that we're going to be reporting on in a few weeks, we use this privacy QA data set, and there's another publicly available legal data set as well. But I would point people to that GitHub, and his name is it's a German name, Berhard Wahald, but I can share that perhaps in the chat, or I can share it with you, Arnab, and you can share it with the materials from this. But that would be a good starting point. And I'll mention that it's not just Berhard who made this available. He was the one that sent out the announcement to the AI and law community. And I think this may have been published on the group, the AI and law group on LinkedIn as well. But this represents the work of many people within the community. And he was simply just the messenger and the person that kind of consolidated these resources on this hub site.
So is it called open legal data? Because I just Googled it and send me one link from Berlin, which is called open legal data.
What's the author's name?
Author's name It doesn't say, it tells the group's name, not author's name, openlegaldata.io. That's what they say.
That may be it. That may be it. I mean, the thing that strikes me is his was a little broader in that it spoke of resources, not just data, but there was code, there was other guidelines and things like that. So it was a broad spectrum of resources that could be useful to legal researchers.
So Stephanie Oaks is saying Bernhard Wöltel is the name from the Liquid Legal Institute.
I think that's right. He was the one that initially distributed the message of this resources.
Okay, thank you.
And if they're not there, I can cite the two legal data collections for question answering as well. If they're not there, I've already mentioned the privacy QA one. There's one other one as well.
Okay, and the explainability also. I mean, I think you can read the question. So, explainability is a key component. So, how far we are in this direction as per your assessment?
And by the way, forgive me, but there was a second part of that first question.
Okay. Yeah. Sorry, sir. Yeah.
And I'm not sure I answered that.
Sorry. Even I forgot. Sorry. So, what is the most popular and stabilized legal domain, subdomain that has been studied and automated by applying AI and ML techniques?
To be honest with you, if you asked 5 different people in the AI and law community, you would get 5 different answers. And the reason, remember those demographic slides that I shared of the 3 concentric circles between computer science and philosophy, in reasoning and law. And some people participated in one of those communities, some people practiced in the intersection. So depending on who you ask, some people might be talking about certain legal reasoning systems. Because I come from the computer science side, I would say that, again, some of the capabilities we just talked about towards the end of my talk, tied to BERT and some of these transformers and how they've been kind of revolutionizing and coming up with state-of-the-art results for text classification and summarization and machine translation and question answering and things like that. I think that I can't say that's the biggest, but it's certainly making an impact. It's moving the needle. And I think that we're going to be seeing a lot more activity and a lot more interest among newer researchers in those areas. But again, that's my view. That doesn't necessarily represent the view of all of the participants within the community. If you have somebody whose principal background is in law itself or in reasoning, they might be talking about some recent developments in their subdomains. But clearly, just as deep learning and neural approaches have been making an impact in the general communities, ACL and NeurIPS and things like that. Similarly, they've been making inroads in the AI and law community as well. And in particular, most recently, the community may have been slow to adopt. But now we're starting to see through some of the papers that we looked at, or some of the papers that will be published in the very near future, we're starting to see that those may be game changers.
Right. So the other question is, how far are we in this explainability as part of your assessment?
It's interesting. What one finds is, there's some research works coming out even from places like Google or other enterprises like that, maybe IBM, on that. And many enterprises are coming up with AI principles. Even Thomson Reuters has a set of AI principles that are fairly general, but they're basically trying to capture the trust of their clients and their customers, letting them know that to the extent possible, they will try to use the best practices and to make sure their data does not have biases, and ultimately that it serves fair and equal access to justice, right? So these are reasonable preliminary steps, but there's still work to be done. There's, to take an example, Northwestern University in Chicago has created a series of activities and workshops and summits called the Machine Learning Impact Initiative. and they're bringing together people from academia and industry and customer groups, customer well-being groups, and they're trying to basically create a roadmap for what would be the most appropriate research to create kind of successful approaches to AI and ethics. I mean, that's the big tent. But underneath that, of course, are the topics of explainability, transparency, interpretability, and things like that. So the short answer to that question is we're still at the inception. We're still at the early stages of that, and it's a field, a nascent field that is still only maturing. And I think in the next few years, there's going to be a lot of development beyond just general principles that a lot of organizations have adopted and have written some papers on.
All right, we have two more questions. So what are your views on privacy and how privacy is managed in this, I mean, the legal data mining? How is privacy managed?
Okay, I mean, this is kind of related but different topic to the one we were talking about, because you could argue that it still falls under the umbrella of AI and ethics and the proper treatment. And so I work for Thomson Reuters, and technically our headquarters is in Toronto, so we're in North America. Again, I can have one perspective on how important this is and how critical this is and how this should be a part of the DNA of any research group that's putting together an application that's using user data, whether it's personal information or preference information, or whether it's based on user activity logs, which is another form of, arguably a form of privacy data. That's one vision. But I think, again, if you were talking to a European from, let's say, a European-based company or a law firm, and they have to deal with GDPR, especially from the European Union, right? And so there's a set of strictures there. There are some other jurisdictions like California who've kind of come up with their own approach to that. That's just one jurisdiction, one state in the U.S. But it's for any serious enterprise that is providing services for law firms or legal practitioners or the courts or governments. And they're providing applications and legal solutions for these kind of practitioners, especially if it spans borders. Then not only will the principles of GDPR have to be met, but I think that some of these enterprises should hold themselves to higher standards for two reasons. I mean, just because of the critical nature of privacy data, you should probably adhere to the strictest standards, which right now are GDPR-like. But beyond that, if you're dealing with legal practitioners, I hate to say it, but if you get it wrong, then you're going to subject yourself to litigation, to liabilities, right? To lawsuits. And so there's another reason in that just by virtue of the very field, I would say that the stakes are higher and the standards are higher. So I can't think of any other field, with the possible exception of the medical domain, where there too, one's personal health information is invaluable and has to be protected at all costs. But with the exception of the medical field, I can't think of any other field besides the legal field where that would be critical.
All right. So one last question. So Amit Singhal is asking, are there any efforts to build certain models that can be agnostic to the geographical regions or countries? Because most of the works might be limited to a specific country.
Sure. I mean, in fact, we have some experience in that too. I guess there's a few ways to do it. I mean, you could try to come up with models that are developed just using the data from a given jurisdiction. But given even in the U.S., you have 50 state jurisdictions, it gets to be a bit cumbersome and impractical, you could say, perhaps, depending on the use cases and the size of the users. So it all comes down to how you treat your training data. And it might be possible to mask some jurisdictionally specific elements in your training data, such that doesn't factor into the models that are created that might create some unintended biases, for or against certain regions or certain jurisdictions. I mean, that would be one approach. I guess it really, it depends on the use case. Again, certain use cases might invite an enterprise to develop certain models for important regions or important jurisdictions. In that case, you might want to create separate models. But in other use cases where you really just don't want to have to deal with it, you don't want it to impact the performance of your system, then you could try to sort of anonymize it. And there's probably other use cases that might have some sort of a hybrid approach, something in the middle.
Right. Yeah. So, I mean, thank you again. So, I mean, we don't have any more questions. We don't have any more time either. So, let's thank the speaker once more. Thank you very much for this fantastic talk. So, we will close this